All right, this is a topic I keep seeing go by in the comments, and it's been something we've been discussing on the YouTube channel then. But I would like, maybe you can explain this, because I've been trying to explain it, but I think this would be a good opportunity for you to explain as well. There has been this idea that has come up, and especially Legal Eagle published. Did you see the Legal Eagle video on this?
I did, yeah. Although I have to confess, I watched it at sort of like 1.5x, so I'm not sure I kind of got everything I was intended to get out of it.
Okay. After the Legal Eagle video hit, there have been a lot of people putting in the comments of my YouTube videos that, oh, well, we never needed the OGL anyway because game mechanics can't be copyrighted. And I think they're forgetting the importance of the SRD and that it's giving you access to the SRD. So if somebody came up to you and said, oh, all this is irrelevant anyway, you don't actually need any kind of license, the OGL was not important, game mechanics can't be copyrighted, how would you explain it to them that is not the case, if it is in fact not the case?
I think it's not the case. I think the OGL was required, and I think there's a few different reasons for that. So one is, it is absolutely true that certainly under U.S. and Canadian copyright law, game rules or game mechanics or game processes cannot be protected by copyright. But that doesn't go, I think, quite as far as people sometimes think it does. And so what I mean by that is a couple of different things. So one is we have to keep in mind that that sort of axiom of copyright law, that you can't copyright mechanics or processes, and you can't copyright the rules of games, grew up in a context where the rules of games were frankly just a hell of a lot simpler. Right. We're talking about a rule that developed like in the 1800s, in the early 1900s. So we're talking there about, and I don't mean to be glib, but like, the rules of checkers. So you have to recognize that role-playing game rules, particularly something like AD&D, like it's just a different category of thing from the rules of a simple game. The other element that I think has to be borne in mind is oftentimes when we're talking about the notion that you can't protect the rules of a game, or you can't copyright the rules of game, part of the rationale for that is to protect users from playing the game and finding themselves on the receiving end of an infringement lawsuit. So what I mean by that is, let's take a complicated game, right? Basketball, like NBA, like pro level NBA basketball. It's got a lot of rules. If somebody plays basketball in accordance with the NBA rules, we don't want the NBA or any other sports league or anybody who sort of purports to own the rules of a game, we don't want them to be able to run around and sue people for copyright infringement because they are playing the game without the NBA's permission. We don't want the NBA to sit there and say, you're infringing our copyright in our game rules, right? So that's what we're trying to protect against. So when we talk about protecting the rules of a game in this context, we have to keep in mind the rules of Dungeons and Dragons are really freaking complicated, right? We're talking about like in every edition of the game, we're talking about hundreds and hundreds of pages of rules. Whenever we write down those rules have been expressed. They've been expressed in a literary work. Literary works are protected by copyright. So we have to draw a distinction between saying the rules of the game can't be protected by copyright, true, but any particular expression of those rules can be protected by copyright, particularly when we have a really complicated set of rules like D&D. There's lots of different ways of expressing the rules of D&D. There's probably not nearly as many ways of expressing the rules of checkers. So the notion that we don't need, or that there isn't copyright protection for the rules of D&D, like I think is just too reductionist. Like it's an overly simplistic way of approaching the question. The other thing we have to keep in mind here is the game is meant to be played. It's been played for decades. So there's a social context in which we have to talk about D&D and the OGL. And part of that context is that in the 1980s and in the 1990s, then TSR, the owners of D&D, were really aggressive enforcers of their intellectual property rights. And they were routinely sending out cease and desist letters to competitors, to other publishers, to game players, to people who were uploading materials onto the internet. And they were, policing their IP in a very aggressive way. So there was a lot of uncertainty on the part of hobbyists as to where the line was drawn. So it's fine and good for us to sit there and say, oh, well, the rules of a game can't be protected by copyright. Okay, that's true. And then when somebody gets a cease and desist letter, from a law firm on behalf of TSR saying, you better stop doing this, or, we're going to sue you in federal court for copyright and trademark infringement, like sitting there and going, yeah, but the rules of game aren't protected by copyright. That doesn't help them very much. It sucks to get a cease and desist letter. It sucks even more to get sued for copyright infringement, right? So one of the reasons why the OGL was so important was because it took all of that off the table, right? It was WotC at the time saying, we're not going to sue you for copyright infringement if you abide by the terms of this license. If you use open game content, we're not suing you for copyright infringement. That was a really radical position, and it was a really radical change from what the situation had been during the 1980s and 1990s. So yeah, I think that's an extremely long way of answering the question. I think it's too simple to say, oh, you never really needed the OGL because the rules of game are protected by copyright.
Well, I don't think it's too long-winded at all. I think it's a great explanation, but I also think it goes into the other thing that I want to talk about specifically on this subject, which is talking about that area of legal ambiguity, because Legal Eagle also kind of very quickly brushed by that. He said, oh yeah, there's also something about reducing some legal ambiguity in this area. But that was also no small part of what Ryan talked about and like why this was so important, because, okay, there is this legal ambiguity. And now here with the OGL, another one of the revolutionary, visionary, whatever word we want to use here, is that let's just eliminate that ambiguity so that investors can come in. They don't have to worry about that, operate according to the terms of the license. It's real.
Exactly.
And so do you want to speak on the need to eliminate that ambiguity when you're talking about in the legal situation, especially in terms of investment and company creation?
Yeah, I mean, I think it's part of what we've sort of touched on already in the sense that, copyright law, trademark law, intellectual property law more generally, they're just kind of complicated, right? You don't want to dabble in them, even as a lawyer. Like, you don't want to be sort of like a litigator who handles employment law, and then somebody lobs in a question about, well, is this copyright infringement? Like, you shouldn't. That employment lawyer shouldn't feel qualified to answer those questions. So to ask people who are not lawyers, who don't have a legal education, to kind of wade through these questions and try and figure out what the right answer is asking a lot of them. And the reality is that in light of that complexity and in light of the ambiguity and in light of the enforcement history of TSR, there, up until the late 90s, up until the year 2000, you did not see a large, an appreciably sized industry creating materials that was expressly meant for use with Dungeons and Dragons. You saw a lot of competitors, certainly, although we have to bear in mind, during the 1970s and 1980s, TSR was throwing around a lot of threats of lawsuits against their competitors as well. But the OGL was meant to reduce ambiguity, and it clearly and demonstrably had that effect, because once it got released, we had this explosion in the number of game publishers. And I use publishers in a really broad sense there, right? Like, we're talking companies, like separately incorporated legal entities who, had employees and had, shareholders and who were publishing things. And that includes just individual hobbyists who were just interested in creating stuff and getting it out there and making it available for their friends, their peers, other people in the community to use. We saw an explosion after the release of the OGL of all of those different types of publishers making content available. And I think it's self-evidently the case that was because the OGL had clarified what the rules of the game were, in a sense, right? Clarified when it was possible or permissible, or it wasn't going to result in you being on the receiving end of a lawsuit if you did these things. And lots of people wanted to take advantage of it, and they did. And that was great. That was great for the industry, right? Like, that was great for players. That was great for publishers. That was great for everybody involved in the industry.